Joining us again. She Athelbrand Shep being Patwitney Nishla, Nakai Bush's Chain, Sitna Jenny Dashache, Ado Nakai Dashanella. I'm happy to be here with you today to talk about two very important topics with respect to the nation's water rights and Navajo water law in general. We're first going to have Mac present on our Utah water settlement, and then we'll have Michelle present on the law of the river, and we're hoping to have some time at the end for Q&A as usual. And I just want to thank everyone, all of our viewers, for the robust questions you had last week and the really great back and forth and shared learning that we all were able to benefit from. So we may have some logistical surprises along the way in today's presentation, just because we're all in the same room. So bear with us as we try to smoothly transition from one person to the next. And actually today we are dialing in from the Colorado River Water Users Association meeting. We've been here the past couple days, had some very important meetings to advance our Arizona water rights settlement, and then also to share information, learn information from our federal partners and from other tribes that pull their water from the Colorado River, both upper basin and lower basin. It's been a really wonderful experience. We had a number of our delegates with us here today. We had Chairwoman Jesus presenting on a Facebook Live on my page actually this morning in a sovereign to sovereign conversation with Bureau of Reclamation. So we're really happy to be here and continue the work of advancing the nation's water rights, protecting those rights, ensuring that our people have access to water, no matter what state lines attempt to traverse the nation. And so before, with no further ado, I think I'll hand things over to Mac. So bear with us as we try to do this transition.
Yat-e. MacArthur Stant, and my clan is Senjikin, and I'm born for the Hawaiian people. And I feel really honored once again to talk to you about something that is important for all of us. And I'm grateful for the membership and your interest in water. Last week, I helped to present the theme and the topic of Indian Water Rights 101. And one of the things that I shared that was very, very important is the concept that Indian water rights is an issue that concerns all of the sovereigns of the country: tribe, Navajo Nation, federal government, and then state governments, depending upon what part of the nation we are referring to and what state they are involved with. Now, today I feel very fortunate that I'm able to give you an example of exactly how Indian Water Rights 101 can be applied, because today we're going to focus on the Utah water settlement. Again, very important example. And so we're going to begin with the slides and work our way as an example. Now, I like that this title has both settlement and adjudication. And this is important because this involves both of the other sovereigns that we're referring to, that the federal government and the state governments, they have certain responsibilities or obligations or relationships and responsibilities with the Navajo Nation in doing these sort of things. So this is important. Today we're going to talk about both settlement and adjudication, and these issues deal with any of the states that we deal with. I want to just give you a visual, because it's a wonderful thing to be able to understand and see what we're referring to. As you can tell, this map is of the Navajo Nation. And as you see, that rectangle, that brown rectangle, represents the part of the nation that's in the state of Utah, which we will talk about today. Now, in a larger concept, we're also talking about the whole state of Utah. And because of that, I want to show you a map that, again, points out in the lower right-hand corner a map of the state of Utah, And then the larger map that's in the center is focused on the nation's lands in Utah and the tribes that it affects. So this is the concept. Now, this next slide, I think, is the most beneficial slide to understand this particular settlement and adjudication. And I'm going to be saying that throughout this presentation, that it's both, that we need to have both a settlement and an adjudication, and that these activities, these legal events, involve all three of the sovereigns. Now, as you notice, in 2003, it says the Navajo Nation, a sovereign, and Utah, a sovereign. So those two sovereigns were engaged in negotiations, and that's when they began for the Utah settlement. Those negotiations began between those two sovereigns. Next, in 2015, again, the same two sovereigns, Navajo Nation and Utah, the settlement agreement was reached. So in terms of actually having the settlement agreement, it involves both the state and the nation. If you notice now in 2020, now we have the federal government that is a part of this aspect, which is the settlement. And in 2020, the federal government was able to give congressional approval, which means now in the settlement, we had the Navajo Nation, which was able to give their approval. We had the state of Utah, which was able to give its approval. And then what we did is we have congressional approval. So up to this point, all three sovereigns are included. Very important thing, because this is what happens in any of the settlements that we have, that the state involved, the nation involved, as well as the federal government. Now, that next part on the timeline, May 27th, 2022, this is the signing of the settlement. And as you notice, it does have all three sovereigns: the Navajo Nation, the federal government, and the state of Utah. So very important, and again, a very important part of basically Indian Water Rights 101, that when it comes to our water rights, we need to have the participation of all of them. Now, we've told you a little bit last week of why that is, and I'll remind you as we move forward, because the current settlement for Utah is very much on the mind of the nation, and very much right now in the process as well. And when I say process, if you notice, the next bullet or on the timeline is now. What is happening now? What's happening now is it's the state government, the state of Utah. They are participating in their adjudication process. I hope you remember that what happens is that when it comes to water rights, states are able to give adjudication, which is litigation, but in court, and they're able to give a decree. And that decree gives that actual water right from the state. That is also looked at by the federal government and is awarded to the nation or other tribes in that context. So right now, and the expectation from the state of Utah is that this state of Utah adjudication, which will result in a decree, which is a judicial legal document that will firm up and provide the nation with the water rights in Utah. That is happening now. And as I said, the state of Utah will continue to work on it. And the expectation is for it to be completed in the year 2024. So next year. What's happening next after that Utah adjudication is that the Navajo Nation, this is where we will start to implement and start to do project studies on how we want to use federal funding, which is a part of the settlement, another part of what the federal government has done. So project studies for this area, then project selection, and then project implementation. And I understand that that's a very important part that the members of the nation and in Utah chapters want to know about. So adjudication, once again, means it is the judicial part. which means the court action. So in any of the states where the nation is getting water rights, we need to go to court. Now, litigation is where you have opposition and you have a judge decide, but adjudication is where it is complemented, and the states and the federal government and the tribe work together so that that necessary element of a state decree can be achieved to make sure that the water is firmed. So that is what a state adjudication is. So we do have several things. We have the settlement. Now we have right now is the state adjudication. And then what will happen after the adjudication is complete will, at the same time, the nation getting ready to implement the projects and through the studies and through the selection. So again, this I think is hopefully a very useful slide and very willing to help people understand it as time goes by. Now, in terms of the settlement, let's just go back and go over a few of the things that are very important about a settlement. And again, we talked about this about litigation and the concept that one of the benefits of a settlement is funding and that it will help with the infrastructure. So here are some of the highlights of the funding that came from the Utah settlement. So we have these numbers that I'm just going to let you look over, but the idea is it's very fortunate that because of this settlement, we are able to get significant funds to move forward that the nation can use in its future projects to apply on the nation. Another important aspect is that fund management plan and how we can move forward in also getting the funds to properly use them for the nation and for the infrastructure projects that we have. So all of this is entailed, and just to give you a familiarity, NUWRSA, Navajo Utah Water Rights Settlement Agreement, Fund Management Plan. Now I'm coming to the end, and I know I used most of my time on that timeline slide, but that was very, very important. Just the overall basic idea of what is happening. And these last few slides that I'm sharing with you are just more details to give you an idea of how this will start to really affect the chapters in Utah and as we move forward, because I understand now that we have a settlement, when do things start to happen? And that's the concept here, is that we have the state of Utah that are doing their adjudication, which will come out with a decree, and which is a judicial legal authority of solidifying what we gained in settlement. So here are some examples of some of the areas that are happening in water project studies. Now, the last slide, though, I want to show you is this other concept, this concept that is now occurring. This is the Utah adjudication process. It's a judicial process, and it will end up, if you notice, at the very end with a water decree. And that's what we're happening. So there are times where members in the chapters in Utah, you might hear a notice of a meeting for your chapter. And if you notice, there are several things here that the state of Utah must inform the membership of the state about, the membership of the nation about, as we go along through this process here. And it's about the claims that are around the area, and then periods in which there can be comments made about this. And then finally, as we get to a state recommendation, okay, the state recommendation is then set to the court system, the judicial system. And then after that is reviewed, then what we do is we have that opportunity, and it will finally be that decree. Again, another way of saying it is it's the court, which means judicial, and that is an aspect and a part of how state water rights are given out. And again, this is what's used for Indian water rights. And that is why we're going over this. But I'm grateful for your time, and looking forward to listening to the Law of the River, which is also an umbrella for all of these as well, which also is very important to Indian water rights. So once again, Akiha. Thank you.
Okay, can you hear me now? Can you hear me now? Okay. Yes, now they can hear me. Great. Sorry, as the Attorney General warned, we may have had some technical difficulties, and so of course that came while I'm talking, so my apologies. Again, my name is Michelle Brown. Tachi Ninchle Anathana Bashishchin, Senajini Dashiche, Anathana Dashanella. On my father's side, I'm Oglala and Salishin Kootenai, and I'm originally from Torreon chapter located in New Mexico. So today's presentation that I'm going to give is the Law of the River. And this presentation piggybacks off of our Indian Water Rights 101, the presentation from last week. So if you missed that one, it's still available online under President Nygren's Facebook page or on YouTube. So you're welcome to go back and look at that one as well. So I do have a PowerPoint presentation, and I'm going to go ahead and begin that. Let's see. Great. So again, the law of the river pertains to the Colorado River. And why is this important? Well, the Colorado River itself is important. It's a primary water source in the Southwest, and it provides water to many of the western states. And in this area, as we all know, it's a very arid area, very dry. And so the Colorado River is the major water source for the western states. The river begins in the Colorado Rockies and ends in the Mexican desert near the Gulf of Mexico. It's 1,450 miles long, and it's the sixth longest river in the United States. So the law of the river. The The law of the river is a collection of rules, regulations, laws, and other binding agreements that control the water in the Colorado River watershed. It dictates water rights to anyone who is reliant on the Colorado River water. And the law of the river is seen as being important because of how important the river is to all of the water users in the western states. And so it is believed that the law, that there needs to be proper management and restrictions on use of the river, and in order to guide continued use of the river as well. So this was touched upon during our Indian Water Rights 101, the Winters v. United States case. And this case, I'm going to start with this because this is considered the bedrock of Indian water rights. And so it only makes sense for us to discuss this as well in talking about the law of the river. So the Winters case, and you may have heard that the term Winters Doctrine actually began in the early 1900s. The Fort Belknap Indian Reservation had farmed approximately 30,000 acres of water from the Milk River. And this is after the reservation was established in the late 1800s. However, many non-Indian settlers came to the area, and they began interrupting the flow of the water that went to the reservation through diversions, through building dams, and other ways of interrupting that flow. So the treaty that established the reservation did not say anything about water for the tribe. And the case went all the way up to the Supreme Court. In that case, the Supreme Court ruled or established a rule of interpretation of treaties and stated that ambiguities will be resolved from the standpoint of the Indians, and that the purpose of the Fort Belknap Reservation was to create a permanent homeland for them. So the Supreme Court ruled that water was included in the agreement as an implied right, a reservation of a right. So that included the water. And so this case has been, as I said, very important to Indian country in establishing water rights. However, the case left many unanswered questions, not just for tribes, but for all water users. So the question was, well, if there's an implied right, how much water is reserved when land is set aside for an Indian reservation? And how is the amount of reserved water determined? Who determines it? What are the purposes for which water is reserved? Does this include executive order reservations? And who must approve? Who must approve all of this? These are questions that are still out there today. These are questions that are still being answered through litigation, through settlement discussions regarding Indian water rights and so forth, and has been something that has been of issue ever since the Winters case came out in 1908. So after the case, of course, the water users that were impacted by the decision of the court used their political power used their, went to Congress asking for Congress to get involved in this issue. Also, as a result, again, the Winters Doctrine came out in 1908, and you've heard us talk about the Colorado River Compact of 1922. I would say that the Colorado River Compact, which was a meeting of the basin states that occurred here in Nevada, where we're currently at, it was a result of water users, states, politicians, tribes trying to figure out how water claims were going to be handled. All of those questions that were on my previous slide. So let me go back and provide some background. In 1869, the Colorado River was considered untamed. The only water users were Indian tribes and California. The other states feared that California would take all the water under the doctrine of first in time, first in right. Congress authorized the Colorado River Basin states to meet on a Colorado River Compact in 1921, and as a result of that, dams and canals were built. One thing I want to say about the meeting to establish the Colorado River Compact is it did not include tribes. However, tribes were discussed, and the agreements that did come out were to include set-asides allocations for tribes, but tribes were not at the table. The Colorado River Compact that arose out of that meeting, these are the following terms. It divided the Colorado River. It created an upper basin and a lower basin. 7,500,000 acre-feet of water in perpetuity was granted, or it was agreed upon that each basin would receive that amount of water, and estimated the water in the river. So even though that amount was determined, the 15 million acre feet, it was actually an estimate. And then also not at the table was Mexico. However, it was determined that there was an obligation to Mexico. This is a map of the upper and lower basins. And as you see, there are the states. There's the 7 basin states: Wyoming, Nevada, Utah, Colorado, California, Arizona, and New Mexico. Just as the state line boundaries are imaginary, so are the upper basin and the lower basin. And they chose Lee's Ferry as the place where the division would occur between the upper and lower basins. And you'll see that in the northeast corner of Arizona and the northwestern corner of New Mexico and the southeast corner of Utah is where the Navajo Nation lies. So we lie within 3 states, and we're also in the upper basin and the lower basin. I don't know of any other tribe that is in the situation that the Navajo Nation is in regards to being in 3 states and in 2 basins. And as I said earlier, the Colorado River Compact, although tribes were not present during the discussions, it was decided that there would be allocations to the states that would include reserved federal rights for including Indian water rights. There was compact. The compact protects water users who had perfected their water rights by 1922. Includes Indian tribes because of the Winters case, and those are called present perfected rights, or PPRs. In response to the compact, Congress also passed the Boulder Canyon Project Act of 1928. And this was conditionally approved. The compact was not ratified by the states. Congress approved the Colorado Compact on condition that the compact will not go into effect unless it is approved by all the 7 states, or 6 states, including California, if California accepted a limit of 4,400,000 acre-feet as its share of mainstream water. So the purpose of the Boulder Canyon Project Act was to construct the Hoover Dam. This provided that the dam would be used for river regulation, improvement of navigation and flood control, for irrigation and domestic uses, and satisfaction of the PPRs, and many of us know also for power. So the Boulder Canyon Project Act and the Colorado River Compact became effective in 1929 when 6 states ratified the compact. I'm going to go on to the next one. And that 7th holdout, of course, was Arizona. And so that there was additional litigation that one of the longest water rights case that has ever been is the Arizona v. California case. And this is in regards to the lower basin apportionment. So Arizona sued California in 1952. Arizona did approve the Colorado River Compact in 1944. Arizona sued California, and the Supreme Court suit asked for 2,800,000 acre-feet from the Colorado River. A special master was appointed, and the special master did issue a report in 1962. So you'll see that this is the beginning of how water claims are decided and how litigation began in regards to water rights in the U.S. And it's a process that's still ongoing, being developed, and a process that the tribes impacts the tribes and our water claims and our pursuit for our water rights through litigation. So this slide shows the decision of the special master, and I'm going to move forward a little bit quicker so we don't run out of time. And okay, all right. I was told I can take more time. So in Arizona v. California, the Supreme Court decision, the Secretary apportioned the lower basin out of the first 7.5 million acre-feet as follows. So you'll see Arizona has 2,800,000, California more than 4 million, and Nevada less than 300,000. Arizona and California share equally in Colorado River water in excess of 7,500,000 acre-feet in lower basin, with a total to California of 5.362 million acre-feet. So also what was decided in the Supreme Court decision is that all users of the Colorado River water would obtain a contract with the Secretary of Interior. The Secretary must respect the delivery obligation of the upper basin. And as well, the Secretary is free to determine methods of curtailment in times of shortage. And this is something that's really important to what's occurring now as a result of the mega drought that we're currently in. The Secretary must provide water for PPRs in time of shortage. And these are the present perfected rights as discussed earlier. So, as a result of the Arizona v. California case, the federal government took over control of the Colorado River, and the Secretary of Interior is considered the one that manages the Colorado River. This was an unforeseen consequence to the states, the basin states, that this wasn't anything that was ever discussed in compact negotiations or any negotiations between the states in terms of management of the Colorado River. And also, there was a large amount of water rights awarded and considered reserved rights for Indian tribes. How the law of the river affects Indian water rights. Reserved water rights of a tribe can only be used on the reservation. This is a law or rule that has been in place for a while, and it is something that impacts tribes. So with the ever-changing hydrology, this is an issue that does come up in discussions from time to time as well. Another rule is water cannot be transferred across state lines. This rule, of course, as I mentioned earlier, and in showing the map, this is a challenge for the Navajo Nation, being that we are within 3 states. And one of the rules of the law of the river is that water rights cannot be transferred across state lines. We have to go to our states to discuss this constantly, and also it would take Congress to change and allow for this to happen. The next one is similar to the last one. Water cannot be transferred from the upper basin for use in the lower basin, and vice versa. So again, as I mentioned earlier, state lines and the lines creating the upper and lower basins are all imaginary lines. So we're talking about Mother Nature, and we know that water's going to flow where water's going to flow. And so again, this is another challenge for the Navajo Nation when it comes to our plans to develop water infrastructure so that water can be delivered to our Navajo communities. Indian tribes cannot lease their reserved water rights to a water user off their reservation. And so this is another rule that is something that is constantly being discussed and causes, has an impact on decision making in regards to water use for tribes. The law of the river strictly applies to adjudicated Indian water rights. It is important for tribes have more control over the water that is needed for reservations and that flows through our lands if our water rights are quantified. So Arizona v. California, quantification for Colorado River tribes. The Supreme Court in the Arizona v. California case did reaffirm the Winters Doctrine, and it includes executive orders reservations. Priority date is the creation of the reservation, and the water rights for federal lands must come out of the allocation for each state under the compacts, and this includes Indian reservations. I can't see the fourth item there due to the question. So, okay. Each tribe was created before 1929, and therefore their water rights are present perfected rights. Okay, so I did kind of refer to the Navajo Nation in my previous map, but here's a map of the Navajo Nation showing how it lies within the 3 states and also in the upper basin and the lower basin. And in New Mexico, you will see that we are in other basin. There are other basins that the Navajo Nation resides in as well. Okay, so the Supreme Court did agree with the water master's conclusion as to the quantity of water intended to be reserved. The special master found that water was intended to satisfy the future as well as the present needs of the Indian reservations based on the practically irrigable acreage, what we call PIAs for short. The Arizona v. California decree, the result of that, there was a decree entered into in March of 1964, and it quantified a total of 905,496 acre feet of water for the 5 river tribes. And so the final decree was in 2006 with that amount of water for 5 tribes. The river tribes not allocated water rights in the lower basin are the Navajo Nation, the Wallapai tribe, and the Havasupai tribe. However, in 2022, there was a settlement that was approved by Congress for the Wallapai tribe. The Colorado River Basin Project Act. So Arizona won the lawsuit, but it only got paper water rights. You may hear, when you hear water lawyers, we talk about paper water rights, and we also talk about wet water rights. So wet water is water that can actually be put to use. Paper water rights is the award that's received. However, when you and paper water rights are usually achieved through litigation, and the court will grant its opinion. And so it's called paper water rights because it's part of a court opinion. However, in litigation, there isn't anything else awarded, such as funding to develop water infrastructure in order for water to be delivered. So in litigation, we refer to what you get is paper water rights, but through settlement, we say that you would actually get wet water rights, which means it usually comes with funding and the ability to develop water infrastructure as a result. Sometimes it's through projects that are part of the settlement, and you get actual water delivery. And it's very important, especially to the Navajo Nation and the water issues that we're dealing with today, and the decisions that we have to make in terms of do we go through litigation, or do we pursue settlement? So California and Arizona finally agreed on funding for the Central Arizona Project in the Colorado River Basin Project Act. The act provides for the secretary to administer the decree in Arizona v. California, such that if less than 7.5 million acre feet of water is available for the lower basin states, the secretary shall provide California with its full apportionment of 4.4 million acre feet a year. Lessons from the Arizona-California water wars, litigation, as I just explained, a litigation victory provides paper water. Arizona had to go to Congress to get funding for the Central Arizona Project. Litigation can lead to unintended consequences, and I'm not sure why that last bullet there is. unanticipated amounts quantified for Indian reservations. So what this slide is purporting is that although Arizona won its case against California, and they received their water rights, they had a victory, and it was called paper water. They actually ended up having to go back to the settlement table in order to get in order to get funding, had to agree to new terms through a settlement in order to actually get water delivery for their communities. So this is the next set of slides are about the Arizona Water Settlements Act, which is more recent legislation from 2004. And this is what we call the water that was agreed to from the secretarial pool. It allocates 67,300 acre feet a year of central Arizona project water for settlement with Arizona Indian tribes, except for the Gila River. In that agreement, 6,411 acre feet of that amount is reserved for use for the Navajo Nation. However, there are restrictions in regards to that 6411. So we call this the 6411. Within the internal water team with the Navajo Nation, because that it is a very important amount of water, but it was also part of the New Mexico Navajo Nation settlement of the San Juan River Basin. 6,411 acre feet can be utilized through the Navajo Gallup Water Supply Project to be delivered into the Window area of the Navajo Nation on the Arizona side with no cost to Arizona. However, the state of Arizona required, in order for this to move forward, required that the Navajo Nation settle its water rights with the state before that water could cross the state line. So again, I had mentioned earlier that there are issues because of these rules as part of the law of the river about not crossing state lines. This is one of our obstacles in being able to deliver this water that was set aside for Navajo, is that the state does not want it to allow it to cross state lines until Navajo settles all of its water rights claims with the state. And the deadline is December 31st of 2030. And so this is a challenge that we're currently working with now. Okay, Upper Colorado River Basin Compact of 1948. The main purposes of this compact was to apportion the waters allocated to the upper basin by the Colorado River Compact and to assure the delivery of water to Lee's Ferry required by Article 3 of the Colorado River Compact. And here are the details of that compact. And what's important for us to know is that 50,000 acre feet a year of upper basin water was allocated to Arizona. And that 50,000 or the upper basin, the Navajo Nation lies within the upper basin of the Arizona portion. And so the 50,000 acre feet would sure come in handy for the Navajo Nation. And the 50,000 acre feet is considered the most reliable water on the Colorado River, and that would be for Arizona. Okay, Indian water rights, quantification, Arizona Supreme Court decisions. So again, this presentation is about the law of the river. And I'm going through these compacts, federal legislation, Supreme Court opinions, because that's what makes up the law of the river. And also, one of the decisions that was made was that Indian water rights or water settlements are to be determined in state courts. We call that the McCarran Amendment. And so our litigation, our cases are actually heard in state courts. So in Utah and New Mexico, we have settlements. They were part of the adjudication in state courts. And in Utah, although we have a settlement approved by Congress, we're still in adjudication with the state to finalize, to have a decree on our settlement. And so you may have heard in previous presentations as well, is that we were in litigation in Arizona in regards to our Little Colorado River claims. And so it was decided that it would be state courts that make decisions on Indian water rights and water settlements. So the Arizona Supreme Court has made decisions that are now part of, I guess, part of what you would call the law of the river. And so there's the Gila River cases. Gila River 3 is a federal reserved rights extend to groundwater to the extent groundwater is necessary to accomplish the purpose of a reservation. And also federal reserve groundwater rights may be protected by injunction. The limit to the extent that greater protection may be necessary to maintain sufficient water to accomplish the purpose of a reservation. Gila River 5. PIA is not the exclusive method to determine Indian water rights. PIA is the practicable irrigable acreage. And as we all know, that not all tribes are situated the same way. So if it works for one, doesn't necessarily mean that it works for all. So the only fair way to determine water rights for Indian tribes is to take all uses into account, but including PIA. So, and then what that also means is agricultural, domestic, municipal, industrial, cultural, population, past use, and resources are considered. So when determining Indian water rights, all of those uses must be taken into account. Also under Gila River 5, quantification of water rights for tribes can be done on a case-by-case basis. In showing need for water, tribes may present a master plan or other methodologies. Gila 4, the interpretation of Winters, unintended consequence. The Winters doctrine includes the concept of a minimal need. This is, of course, an issue for tribes when trying to have our water rights determined for a permanent homeland. We're thinking about our future. We're thinking about the impact colonialism has impact our way of life. And although we are in 2024 or 2023, we still, have the impacts that we deal with as a result of decisions from the federal government. And one of those that was really highlighted in our litigation this summer in regards to the Little Colorado River is that we have a lot of our people that move off the reservation in order to go to school or to get jobs. And one thing that we really tried hard to show is that although that is the case and the population seems to be, moving up and down, that as Navajo people, we do believe in returning to our homeland, and that we do want to return in order to continue as Navajo people, and that we want our future to always be able to return and establish a permanent homeland. But without water, it has been very difficult to do that. So we did see in the same case, the special master in quantifying Hopi water tailored the amount of water to the minimal needs of the Indian reservations. And so now I got through my PowerPoint presentation, and we would be happy to answer any questions that you may have.
So I guess I will pull up the questions. Don't mind the lovely exit sign above my head. Let's see, we have, glad to hear there are lots of ears that are working now. We have Julian Taylor, I believe, saying, could you provide this information at the chapter levels in Navajo? I think it would be taken more seriously that way. Well, hopefully everyone's taking it seriously now. This is not meant to be anything other than serious. But we do have a plan in January to do a public education campaign, particularly on the Arizona side of the nation, because we do have our Arizona water rights settlement negotiations that are underway, that are very expedited and very important, because we are going into a period where there is something called the post 2026 guidelines, and we want to make sure that we have perfected rights in the upper basin and the lower basin in Arizona, so we can have an equal seat at the table with everybody else who has perfected rights on the river in the two basins. And that is taking into consideration the impacts of climate change that have been intensifying, and in my view have evolved into climate chaos at this point, because it's so difficult to predict what lies ahead. And we saw that with the very wet year last year, and now what so far appears to me to be a very dry year. And also is not really aligning with predictions from the Farmer's Almanac and whatnot. So that's, adding to emphasizing the uncertain times that we do live in right now. But the public presentations will be done at the chapter level. Not every chapter, unfortunately. We do have 110 chapters at the nation, and it would be very difficult for our team to be able to go to every single chapter. And that's why we want to make this information available virtually as well. We certainly will do our best to provide some Navajo translation. So I'll make that note for our team. So thank you for your comment, Julian or Taylor. And then we have Vincent Yazzie saying all parties need to be contacted on a settlement as a courtesy before presenting to council. Thank you for your comment, Vincent. We'll certainly take that into consideration. I'm not sure what you mean by all parties. Let's see. Vern says the 7 western states are in discussion to determine the future Colorado River in Las Vegas this week. No is absent there. Why? I don't really understand that question. But we did have a strong contingent from the nation here. We had our chair of the Resources and Development Committee. We had our chair of our Water Rights Commission. We had another commissioner present as well. And we also had a number, basically our entire Water Rights Unit team and myself here as well, strengthening relationships, continuing to move forward discussions relating to settlement. We actually have 3 live settlement negotiations underway right now. And so we're taking this very seriously. And this was a very productive week, actually. It had some very productive meetings, and lovely to be able to do it in person as well. Um, Jerry Begay has a question of what is quantification? And so essentially, when we're in an adjudication, we go in knowing that the nation has rights, and we have superior rights, reserved rights, but it's not clear how many acre feet per year we are able to draw on. And so the adjudication process quantifies those rights. It translates the use and activities of water that we have been practicing and using our land for, and then it converts that into a number essentially. And what we've seen, certainly with the Hopi's adjudication in the LCR trial, is that it's a very reductive process. You're essentially having to justify every acre foot, whereas in a settlement, it's just sort of, you're going in and it's much broader. You're not having to affirmatively prove every acre foot the way you do in an adjudication. So, and that's why I call an adjudication a reductive process, because you really have the burden of proof to establish your right to each acre foot per year. And as we know, tribes have been very good at conserving water and being able to do a lot with little water. And so that actually works against us in the adjudication process because we've been so good at conservation and we have not been using the high volumes that off-reservation communities use. Let's see. Okay, we have, let's see this next question. Okay, that was not relevant. Someone had a question about Navajo quantification, especially for former Bennett Freeze area. So the former Bennett Freeze area is in the lower basin of the nation. Michelle may want to say something, so I will defer to Michelle on this.
I think we were just working through our technical difficulties, and I got brought back up on the screen to help with any questions. If anyone has any, if you want me to answer any of the questions, AG. Okay, I can do that. So I know that I see a few questions that are referring to some of the comments that I made towards the end of my presentation about when we're preparing for or are working on litigation and settlements, that there is this desire of Navajo people to return back to the reservation. And yes, of course, it's going to take a lot of planning, and there's a need for development. We know that there's a need for housing. There's a need for economic development. There's a need, for establishing jobs and so forth in order for our Navajo people to be able to return back to the Navajo Nation. So we see so in preparation again for litigation, we are taking into account, the Navajo Nation population and trying to be persuasive. We had quite a few witnesses in our LCR litigation that talked about, the importance of a permanent homeland for the Navajo Nation because Navajo people do want to return. But water is so paramount, and so our leadership has made it a priority for us to have our water rights claims pursued, and also to be able to in order for us to do all the things that it's going to take. So trying to think what so it's something that we're working on, and we know that water is basically very important to all of the planning and preparation that it would take. So great questions from Car Rye and from Cindy Moggen. Let's see, let me look at more questions here.
Michelle, I can see.
Okay, the AG is going to take a couple of.
Hi. And I apologize if I'm repeating something that Michelle said. I am not a multitasker. I don't believe there's such thing as multitasking. And so I missed what she said. But I see this great question from Cindy Mon, and I think I see some of this in Carrie's question as well, about whether we're planning and preparing for uh, our entire population to return. And that certainly is a big part of our adjudication, is establishing the base of population for which we're trying to secure water rights 100 years out, essentially. And so in the adjudication, we actually end up with somewhat of a battle of the experts, right? We have all these population experts. Every party essentially has their own expert. Actually, there are really only 4 experts that we're dealing with, and they all have different views. And the nation's population is many of our people live off reservation. So not only do we have to establish what our population is going to be, but we also have to establish a presumption that our population will be returning. And so I'm not going to go into that in detail because that's the subject of litigation at this time. But certainly when we are doing that adjudication process, we are planning for that return, and we're trying to secure and ensure that if there is a full return of our people, then we will be able to provide them with water. Michelle, did you want to add anything further based on additional questions?
I think these are all great questions, and I really like the interest that people are showing in how water rights, the pursuit of our water rights, actually what's behind it and what's occurring, and that's the purpose of these presentations. And I think there was one question that said something like we have to prove that we need water infrastructure. Yes, that was from Jerry Begay. So we would need to prove that we need water for infrastructure. Yes, when we're in litigation, we do have to bring it all out to show what the needs are. We even find ourselves having to show how much cattle, how much wildlife there is, what kind of agricultural use is out there. And this is a result of, laws, the law of the river, the case law over a span of 100 years is it does require, because we're dealing with, those decisions about minimal use or, practicable, irrigable acreage. And so we do, in pursuit of our claims, we do have to prove our population, how many people reside within not just the Navajo Nation as a whole, but in what basin and what the water use is. And we take, our job in having to gather all of that evidence very seriously. And we work with all of the departments within the Navajo Nation. We reach out even to those that have left the nation, to be able to help gather information and why they left and what their plans are to come back in order to really show a good case. And then Jerry Begay also asked about tradition. Well, I'm assuming it said wood traditional, but I'm assuming that do we also consider our traditions and culture in presenting our case? And yes, we do. AG, did you want to add to that?
Yeah, I just wanted to respond to some of the questions from Carrie about what we are doing to facilitate the return of our people to our homeland. And that is part of the president's 1,000 Home Initiative. So there's a lot of things that are happening behind the scenes right now in Navajo Nation government across divisions. It's coordination like I've never seen before at the Navajo Nation government level. And so right now we're really in kind of like the thinking, planning phase of that, right? And we're going to start execution very soon. So a lot of that is involving development of as many homes as we can. We're not even really aiming for 1,000. We're just thinking, let's build as many homes as we can. Hopefully that's like 10,000 homes or 1,000,000 homes. There's the contemplation of apartment buildings, tiny homes, regular size homes, turnkey home sites. And so we're just kind of putting in place all of the things that are needed as a foundation to make that possible. And then, of course, with all of our home site lease educational presentations that we're doing as well, that's to enable and empower individual tribal members to perfect their home site claims, get their home site lease, get that passed on from someone to the next generation. And we will be having a series of conferences all across Navajo Nation in the coming year that are going to be one-stop shops where you can actually go and speak to people who are processing the home site leases. And there will be, presentations on how to finance, how to get a mortgage for your home site to build your home. So there's a lot that's coming, and I see the question from Jerry for more information on this. I'm going to be providing information on this in depth at the President's State of the Nation address on January 9th. That's going to be at Behodsil Stadium, Fighting Scouts Stadium in Window Rock. So I encourage all of you to come attend that in person. There's going to be a lot of information shared. There will be tables, information booths where you can speak directly with Navajo Nation employees, and you'll get a better sense for the president's work, what we've accomplished in the last year, which has been tremendous, like I've never seen before under any prior administration other than my Che Pizza. And then kind of laying out what we'll be doing in the coming year. So stay tuned for that. Please come on January 9th. That's all of what I wanted to say just to address that question of development. So do we have any additional questions we need to address before we sign off today, Michelle?
No, I think we kind of covered them. I mean, we ask you to continue to attend our presentations and ask your questions, and we're available if you want to reach out. My email address is myazi@nndoj.org. You can also go to our website and find our email addresses. So we welcome questions. We welcome invites. We do already have a plan to go out to different locations on the Navajo Nation in both New Mexico and in Arizona to talk about our efforts to pursue our water rights. So thank you again, AG, for putting these together.
Absolutely. Happy to do it. And thank you, Michelle, and our entire water rights unit who've been working so hard to put together these quality presentations. Really, really appreciate that. Thank you, everyone who has tuned in, and especially those of you who are still with us. It's a lot of information. It's a lot of dry information at times, and that's why we have lawyers doing this work, because that's part of our training. Our endurance is to be able to stick with something that's very complex and dry, and understand and utilize the tools, navigate that to protect rights, and in particular for my team, the rights of the nation in that environment. So I just wanted to, before we sign off, remind everyone that we are in our water series for these Lunch and Learn sessions. And next week, we will be covering our New Mexico water rights. There are a number of basins and subbasins that the nation has rights to in New Mexico. When we have 2 live settlement negotiations underway on the New Mexico side, we just had an amendment. And huge kudos to our water rights team for getting this amendment introduced. And we were able to get Senator Romney to sign on as a co-sponsor for our Navajo Gallup Water Supply Act amendments. And so I especially want to give kudos to Michelle, who played a key role in making all of that happen. You guys should tune in next Friday. There's a lot happening on the New Mexico side, not only in terms of settlements and negotiations, but also the building out of the infrastructure for settled rights in New Mexico. Anybody driving down the 491 corridor or driving between Gallup and Window Rock, you see those pipelines going into place. It's very, very exciting. We already have water flowing on the Cutter lateral side. So there'll be lots of insights about what's happening on New Mexico side in all different respects. So thank you everyone for tuning in, and we'll see you next week. Go on, Ed.